Wants to know about unilateral terminations, huh?
Yeah, we do.
Not really, but we're going to talk about them anyways. How's that sound?
Beautiful.
Excellent. When to use a unilateral termination versus a mutual, and kind of how to properly fill out this unilateral termination is what I want to talk about. First thing that I want to say is anybody who has done less than, I'd say, 10 transactions, if you're going to terminate a contract for any reason, call the broker hotline. Check to make sure there isn't some way that all of our years of experience, we can't save the deal for you somehow. It may be, you may call us and say, this is what's going on, and we'll say, yep, that's a dead deal. But there's a chance, and any little chance that we can save a deal, let's work to try and do that. Okay? Fair enough? When filling out this unilateral termination, just about everybody, I think, knows about the unilateral termination, right? It's probably not the best thing to know so well, but people seem to think they know it well. Top of it is pretty standard. The date that notice is given, of course. If you're meeting a deadline, that needs to obviously be given by the deadline. 11:59 p.m. is the deadline. Don't push it. We had somebody recently that literally sent this out at 11:59. I would say send it at 11:50, 11:30, something along those lines, because if the time stamp on it came back at midnight, it wouldn't be in effect. You would have missed the deadline. All right, so send it a little bit earlier. Make sure there aren't any other deadlines written into your contract. All right. Binding agreement date, of course, needs to be filled in. The top section here, you'll see you have the big fat or here. That or means that only one side has to sign it. Sorry, only one side has to sign it. That is the unilateral portion of this. You'll see lots of time this gets signed by both sides. Or if the other agent comes back and says, I need your seller, buyer terminates your listing, and they say, I need your seller to sign that. No, you do not need the seller to sign that. Only one side has to sign this top section of the unilateral notice to terminate. Check whether your buyer or seller is terminating and giving the notice, right? Pretty simple. The biggest one that's used in most instances is A, buyer's right to terminate within due diligence. That is real clean, crystal clear, to the point. If you're in the due diligence period, that happens on 90% of these unilateral terminations. When you get into failure of the following contingency, which the agreement is subject to, in that section you would write the contingency. So appraisal contingency, finance contingency, the selling your home contingency, home sale contingency. Whatever that contingency is that is within this portion of it, or which is in the contract, that is, we're not moving forward because of, whatever the case may be. Again, if you're not sure, let's talk to the broker hotline and let's try and figure it out. When you start getting into these bottom two, C and D, you should really speak with someone about it. And I say that because you're talking about the following default under the agreement. Probably the biggest one where you would check C is the contract close date has passed. That would be a default on one party. Another instance in it would be if there is a finance contingency. If you read through the finance contingency, you can force the other side to provide proof that they have the ability to close. And if they don't provide proof in X amount of time, then you can terminate the deal. That would be another reason where the buyer defaulted because they did not provide financing updates timely. You can also write stuff in the special steps in the contract that would force that. But when you start getting into that and you're unilaterally terminating the contract, you're definitely going to want to check with one of us brokers to make sure that you have the legal right to unilaterally terminate. So you don't want to terminate a contract when you didn't have a right to. It is definitely going to cause you issues and a headache. Other lawful reason, you need a law degree in order to fill that in. this did just come up where I actually called our attorney and got the language to put in there. Septic tank was not disclosed on the seller's property disclosure. Came up the day before closing when they went to connect utilities in their name. So that is a material change in the condition of the property is what the attorney told me to put in there. I don't know the exact verbiage, but that's why they terminated. Okay? So again, other lawful reason, you should never be filling that out without consulting one of us brokers 100%. Because
death of one of the parties?
yeah, death of a party would be a reason to, would be a lawful reason because obviously the estate can't sign form either until it's gone through probate and all that stuff. So you really don't have a contract with that one. All right, scrolling down here, the proposed disbursement of earnest money is where it comes into, you need both signatures. So, or there and there. So you need this side and this side to agree to release earnest money, okay? Without both signatures, you start the whole 10-day letter dispute process. Who's gone, anybody gone through that here? Yeah, it can go in your favor, it cannot go in your favor. Just make sure that when you're terminating up top unilaterally, that you have a lawful reason to terminate. And that's why I keep stressing that when you guys are terminating, reach out to one of the brokers, make sure that you have a lawful reason. If it is in the due diligence period, that's a no-brainer. You don't need to reach out to us, although we may be able to find some way to find common ground where you guys will think differently than you in the process. So that being said, both sides need to fill this out. Dispersed as follows. How many people just put in there to the buyer? You're gonna put that? Anybody? If it goes to the buyer? That's
Sure,
all you put?
sure, why not? I don't know.
That's really confusing to the holder, whether it's the attorney or it's us. Are there two buyers that it's going to? Do you want the check in both of their names? Do you want the check in just one party's name? What's their address? So that's why that line is that long. So you can say buyer Amos, Dwayne Amos, and then put the address of where it's going to in there. Or buyer Amos, we'll pick up from your office. Whatever they want to do, however you want to disperse it. You have instructions there, otherwise you cause the back and forth of where does the money go to. So you can put more than just to the buyer in it, and I would encourage you to, right? Be specific. So that's a unilateral. You need a lawful reason to unilaterally terminate a contract. If it's gray area, don't do it.
Hey Dwayne, not to
Go
belabor
ahead.
that disbursement issue, when we're holding earnest money here,
Yes.
are our options only check delivered or mailed, or can it be wire?
We will not wire,
Okay,
just because there's a $40 wire fee
got it.
going out, because like the attorneys will do lots of wires because they have a special account that they pay big money for actually. Like I looked into it, it's gonna cost us about $500 a month to have an account that we could wire out of without having regular fees. So no, that's not feasible for the amount that we hold. So yes, just check here and we will UPS it. We always UPS it. We do not send any earnest money checks, period, snail mail or USPS, which has really turned into snail mail. Stuff gets lost, all that stuff. We have full tracking on all of our earnest money checks. All right?
Okay.
All right, so when you're in a gray area and folks are agreeing to terminate the contract, that is when you would use a mutual termination. Anybody, you got any ideas, Jay, on when you would use a mutual termination? You should always try to use one.
The best analogy that I've always learned was mutual terminations are conventional warfare. Unilateral is nuclear warfare. You always want to try to go conventional
And get
before you have to pull out nuclear.
Like, so can we get this mutual termination? We're in the even due diligence period. Due diligence, that's why I said 90% of them unilaterals are due diligence. But even at that, get the mutual termination. Make sense? So with this, It's only mutual upon the, signed by the buyer and the seller, and delivered, just like a binding agreement, signed by the brokers involved in the transaction. Brokers sign this termination as well. It takes away the buyers and sellers' liability as far as commissions are written in the contract. So that's another reason why it's advisable for a buyer to sign it. If they unilaterally terminate, going back to the unilateral, and they didn't do it for a lawful reason, that listing agent, listing brokerage could potentially, you don't see it, but could sue them for the commission. Something that could happen. So get the mutual termination when you can for that reason. You sign it. It also says if anybody's going to pay any amounts, who, as far as the brokers,
Is that normally zeros already?
Zeros.
Yeah.
Yep. Zeros would be the same thing as a unilateral termination, except the zeros actually remove the liability of the buyer or seller.
With the mutual, when does it become effective? When both parties sign, or immediately when it's sent?
When buyer and seller sign.
So if you're in a time crunch, you use unilateral.
I was going to get to that. But you're absolutely right. This does not terminate your contract and does not get everything gone. So, but when you can, definitely use this mutual. Time crunch, you're right. You just have to fire off that unilateral to protect the buyer's earnest money. All right. It also has the disbursement of earnest money section here. Be detailed in that section. All right. Lots of times, a contract will be terminated to protect the buyer's earnest money, right? So we terminate it. We're literally, we want to protect the buyer's earnest money. That's one of our duties as selling agents, right? There is a form. It is F-290. It's the agreement to reinstate the contract. This is how you can legally reinstate a contract. So it has all the verbiage in here that, you know, buyer and seller agree to reinstate the last fully agreed upon version. With everything else is enforceable. It has all that language to make that contract binding. A lot of times people will just start moving, they'll sign an amendment after the fact, after the termination has been sent to come to whatever agreement. That technically reinstates the contract, but there leaves room for confusion and room for things being not clear, which then you get in front of a judge and you have to go through that whole process. This form will reinstate the contract. All right. All the terms and conditions set forth in the agreement, including buying agreement, shall remain in full force and except any changes thereto set forth below. So that's what that box is there for. So anything you want to change.
Closing date.
Closing
blah, blah,
date's
blah.
now.
Yeah.
Yep.
Next week instead of yesterday.
Yep. You can put in there, and you can check for additional pages if you need to, if you need a whole bunch more information. This agreement to reinstate contract shall only be effective when signed by the buyer and seller and fully executed, delivered to the other party. All right. When using this, a contract has expired, and it expired, say, October 14th. You really shouldn't use this form to try and reinstate that contract. Or you terminated a contract that 2 weeks ago, a week ago even. You really shouldn't use this form to reinstate those. You should do an entirely new contract in those instances. But again, they gave us this form to use, which does make it a legally binding contract again. Make sense? Go ahead.
So if you have a backup contract and for whatever reason it was not used because they went ahead with the first contract and the main contract ended up falling through, can you use that to reinstate the backup contract?
No, the backup contract with the backup contingency exhibit automatically makes that the controlling contract after the first contract terminates. So the backup offer will become the primary offer, and everything will start moving from there on that.
Okay.
And the way to trigger that is a notice of binding agreement date.
Make sense? Any other questions y'all have? Go ahead.
Just a point of procedure when you're doing a reinstatement like this, I would, I would not send this as a single document. Send this in one PDF along with the rest of the contract,
Right.
so that where it says all of the previous, things,
Terms.
it's all in one single PDF document with everybody's signatures on it. Just a point of procedure. That way
That's a
your
good one.
compliance broker's not going back going, okay, I see this one and it's a separate PDF, and then I'm trying to match it up with the
With the
latest
binding
version of it.
contract.
You put it all in one document.
That makes sense.
Mhm.
Trying to make Karen's job a little easier.
Yeah.
I've had Chair Karen's job before, that's why.
Any other questions? Any questions about forms at all in general? We got a few minutes left here. No, nothing?
How often does this one come up?
How often does this one come up?
Yeah.
I've yet to see anybody in our office use it.
We've used it, I've seen it lately.
I said I have yet to. I don't know.
I
if
helped
you have.
somebody with it recently, within the last couple of weeks.
The
Okay.
cooler heads prevailed last minute and they wanted to re-up.
It was an expiration thing, and yeah,
Okay.
the time frame got away.
So yeah. Is that all?